It's 9 o'clock and welcome to an oral argument session online of the 5th District Court of Appeal. My name is Rand Wallace and I'll be presiding over the case, this morning. Joining me on the panel from Marion County, we have Judge Brian Lambert, and from Duval County, we have Judge Paige Kilbane. The case we have on the docket is Simpkins versus Nusser. 2024 2644. I would just ask that the parties, if you have any devices that may make noise when you're doing your presentation, please silence those, and a fail-safe is just to mute your microphone when you're not presenting. And Ms. Haas, I'm going to assume that you want 5 minutes for rebuttal unless you tell me otherwise. And other than that, you can proceed.
Thank you, Your Honor. That is correct. May it please the court, Nancy Haas on behalf of the appellant Jeremiah Simpkins. This case emanates from a final judgment of paternity that was entered by the trial court. This was quite a disturbing case. In this case, a minor child was born to my client and to the mother, Ms. Nusser. Ms. Nusser had an extremely long history of extreme drug abuse. She had lost a prior child to dependency. 2 other children had to be placed for adoption because when the children were born, she was addicted to drugs. And then we have the child that is the subject of this proceeding, who was born in 2020. There was a lengthy 3-day trial. A social investigation had been performed by Kristen Wallace in this case, a very thorough social investigation. In addition, there was another assessment that was performed of the mother by Ms. Pratt in this case. We would submit that the trial court abused its discretion because it essentially ignored the only qualified expert testimony with regard to the status of the mother, wherein it was recommended that the father have majority time sharing with this minor child, and that he also be entitled to ultimate decision-making authority, which in fact Mr. Simpkins had requested both in his initial amended petition as well in his pretrial statement. So the mother and the court were on notice that this was in fact the relief that Mr. Simpkins was requesting in this case. Dr. Wallace gave uncontroverted expert testimony at the trial in this cause that the mother was a polysubstance abuser. And in fact, the paternity order in this case was entered adjudicating Mr. Simpkins, the father, in a dependency action that was pending during the paternity action when the child was in fact adjudicated dependent by Brevard County, and wherein it was specifically found that this child had been abandoned, abused, and neglected by the mother. And yet the trial court, in its analysis of the statutory factors of 6113, completely ignored this adjudication. And the child was in fact sheltered by the department and was placed in the care of the father. So although the trial court did conduct an analysis of the statutory factors of 6113 as it was required to do, it ignored the substantial competent evidence that had been submitted by the father relative to the mother's inability in this case to share parental responsibility and relative to Mr. Simpkins' plea for majority time sharing. In fact, this was a case where the mother worked at a known drug den hotel, where she admitted that while working at that hotel and having the care of the child, that she had been given methamphetamine by one of the patrons, and Dr. Wallace
Counsel, when you say the trial judge ignored the evidence, I mean, the judge was aware of the evidence, but didn't the judge hear other evidence, for lack of a better word, on the mother's side that suggested that she had gotten better, the dependency case was closed, there's no TPR case pending or pursued, and there was evidence that would contradict Dr. Wallace's testimony to some extent, and the judge just weighed that and made the call to do 50-50 time sharing? Is that an unfair read of the record here?
I would suggest to you that, Your Honor, it is an unfair read of the record. And my suggestion is because Dr. Wallace's testimony with regard to the gravity of this woman's drug addiction, her failing to often tell the truth during the course of the social investigation as to her alcohol abuse. And in fact, Dr. Wallace noticed, most importantly, that she continued to consume alcohol during the course of the proceeding and during the course of the social investigation. So while normally the trial court is in the best position to assess witness credibility and weigh the evidence, a review of the record in this case compels the conclusion that the mother did not satisfy the burden of proof to enable the trial court to formulate the parenting plan that it did in this case. And I would suggest to you that the people that testified in this case, Ms. Campanico, who was the mother's quote unquote therapist, was an intern. And she admitted that Ms. Nusser was her very first client. She had no training and no experience. Thereafter, Ms. Nusser saw another therapist who affirmed that Ms. Nusser was a polysubstance abuser, but couldn't even tell you what substances Ms. Nusser was using. So I would submit to you that the witnesses that Ms. Nusser presented at the trial to somehow overcome this burden did not provide the substantial competent testimony that Dr. Wallace provided by her very thorough social investigation, nor negate the long history of drug addiction and abuse in this case. So again,
Ms. Haas, was the word or the phrase present danger ever argued in front of this judge? Kind of getting back to Judge Lambert's question, you're arguing long drug history, which to me connotates the past. Was there ever any evidence presented by your client that there was a present danger to the child?
Yes, Dr. Wallace testified that she believed that the mother was still drinking, and she believed that it was imperative that the father be awarded majority time sharing based upon her extensive interviews, her review of all of the documentation, and the fact that Ms. Nusser was still drinking during the course of the proceeding. Dr. Wallace made that very clear to the trial court in her testimony. And that was uncontroverted evidence that was presented by the father at this trial. I mean, this is a child's life. And for the court not to have erred on the side of caution, given the extremely disturbing history in this case, was quite foundly amazing. And in fact, one of the judge's findings was that the mother had never used drugs in front of the child. And that was directly contradictory to the dependency report and the order that was entered. And in fact, the court took judicial notice of the entire dependency file in the paternity case, consistent with the parties' agreement. So that was well borne out in this case. The trial court essentially relied on speculation and unsupported assumptions about the mother's ability to care for this child, including her capacity to provide a safe environment.
Well, counsel, what about Jennifer Kiss's testimony and others who testified she'd had 50 clean drug tests? I don't think there's any dispute that it seems like drug abuse, extensive drug abuse occurred in the past. But again, we're looking at now. She went through the case plan. Now she's done what she needed to do. She's going to counseling. She's done, 50 clean drug tests. And so what of that? Is the court supposed to ignore that as in favor of Dr. Wallace's testimony? It seems like that you would prefer that. I understand that, but based on our standard, what do we do with that testimony?
Well, it wasn't only Dr. Wallace, though, clearly contradicted that. Dr. Wallace on October 30th testified that I can only confirm that there were some ETG 80-hour alcohol drug screens, urine screens that were positive throughout the process of our investigation. So Dr. Wallace contradicted that. She was the social investigator. She was the agreed upon court-appointed social investigator who had done the most work in this case with regard to interviewing collaterals, with regard to home visits, with regard to observations of the mother, reviewing it an extraordinary amount of documentation, which is well borne out by her report. And in fact, Ms. Campanico, who was the mother's witness, testified that she took the mother at her word as far as her reports were concerned, that she was not drinking. And Dr. Wallace contradicted that. She said there were lots of flaws there in accepting the mother's self-reports. Natalie Pratt, who the mother had only seen for 2.5 months, who was one of the other witnesses called by the mother, she testified that the mother had an addiction to opiates, and she admitted that she didn't know what type of opiates they were. She also admitted that the mother qualified as a polysubstance user, that she had a history of abusing Xanax, Dilaudid, heroin, methamphetamine, amphetamine, hydrocodone, alcohol, and Valium, and should not have continued to consume alcohol. That's what the mother's witness testified. So I would submit to you that the competent substantial evidence in this case supported the father's plea for ultimate decision-making with regard to medical issues and education, and for majority time sharing, which was well borne out in this case. The mother was also arrested twice for driving under the influence. So, and it was a grave concern to Dr. Wallace that the mother continued to consume alcohol, as it was to the father. So, again, despite an adjudication of dependency and despite the dependency court finding that this minor child had been abused and neglected, the court found that there was no direct evidence presented to the court that any of this was done in the presence of the child. And that was absolutely not the case. So again, the court seemed to want to commend the mother for doing better, but that's not the standard in this case. The standard in this case is, does the competent substantial evidence support the trial court's parenting plan? And I submit to you that in this case, it clearly does not. I mean, close in proximity to the trial in this case, the mother was still taking the child to her workplace, to the hotel where there were known sex abusers, where she admitted that she had accepted drugs from patrons. And this was extremely disconcerting. And I would submit to you that the trial court's analysis of the statutory factors didn't comport with the evidence before the trial court. And in our initial brief, we go through all of those statutory factors and how the competent substantial evidence actually contradicts the trial court's findings in that regard. So I would submit to you that in addition, the father then filed, one of the other issues is that the plan that the court put in place for the mother, that the mother simply go to Narcotics Anonymous meetings and Alcoholics Anonymous meetings, was on the honor system. The court didn't even put a plan in place. And in fact, when the trial court made its oral pronouncements and indicated how concerned it was about the mother's drug use and about the alcohol use, and indicated that there would have to be extensive counseling, in the final judgment, that was clearly contradicted. And in fact, the trial court noted that the mother would be on the honor system. So there really was no therapeutic plan in place that could be enforced by the trial court to protect this child. And that is most disconcerting in this case as well. So essentially, there's no oversight. And in the father's amended motion for contempt and enforcement and his motion to reopen the evidence, the father pointed out that there was no oversight or enforcement mechanism put in place by the trial court relative to the final judgment, nor findings as to the mother's inability to attend therapy or as to the cost of same. The mother stated on the record when the trial court gave its oral pronouncements that she couldn't afford therapy. And that was why the father wanted to reopen the evidence, because he knew how critical this component was for the mother to obtain the critical treatment that was required. And yet the trial court decided that that would be on the honor system with someone where the child had been adjudicated dependent, where the mother had a history since she was, 16 years of age of unbelievable drug dependency, had been arrested, had been driving under the influence of alcohol, and yet the trial court did not see it.
Counsel, before you use all your time before rebuttal, do you want to address your last two issues about the delay in the entry of the final judgment and the alleged inconsistencies between the oral pronouncement and the written judgment?
Well, I think that, yes, Your Honor, thank you. And I think that those obviously are ancillary to the more compelling arguments we make in this case. But clearly, 7.5 months passed since the trial concluded and the trial court entered the final judgment in this case. And we would submit to the court that in conjunction with the errors that we believe the trial court committed relative to the entry of the parenting plan in this case, justify the reversal of the final judgment in this case.
Well,
So
let me understand the chronology though. Didn't the judge have a hearing, make an oral pronouncement about the findings, and then it was 3 or 4 months later that the written judgment was entered? Is that significant to you?
it's accurate.
It cuts down the time frame of, well, we had a trial here and then we didn't hear anything for 7.5 months. You heard something after 3 months, and then 4 months later there's a written judgment. That seems to lessen the impact of your arguments in the last 2 arguments.
Well,
Tell me why I'm wrong then.
I'm not going to tell you you're wrong. I'm going to say
Doesn't hurt my feelings. Tell me I'm wrong if I'm wrong.
no,
A lot
you're
of people
not.
told me I'm wrong.
You're not incorrect in your chronology, Your Honor. So I'm not going to suggest that you're wrong. I would suggest to you that standing alone, the delay might not justify the reversal of the final judgment, but coupled with the merits of the conflicts and inconsistencies between the trial court's findings at the time of the trial and the ultimate judgment, that makes it more significant. And with regard to the father's motion to reopen the evidence and the trial court's failure to address that, I believe that in this case, based upon the fact that the father basically went into court and said, there's no real treatment plan that the court has put in place, that the court said this is now on the honor system, that there had been additional evidence that the mother's boyfriend was babysitting the child when the court had directed that no one but the parents should provide care for the child, and that there were allegations, in fact, that the boyfriend had inappropriately touched this child, were significant enough for the court to have allowed the evidence to be reopened in this case. So essentially, based upon what we believe to be a gross abuse of discretion in terms of the entry of the parenting plan, we would submit that the final judgment in this case should be reversed.
Ms. Haas, you're into your rebuttal time, so I don't know if you want to reserve.
Yes, thank you, Judge.
All right, thank you. Mr. Albert.
Yes, sir. May it please the court. Let me briefly address one of the last things counsel said, that the boyfriend was accused of touching the child in an appropriate manner. Those allegations came from the father and his adoptive mother. They were investigated by law enforcement, and DCF and found to be untrue. Regardless, other than that, we start today the same as I did with the trial. Miss Simpkins was one of the best clients I have ever had. Anything that was ever requested of her, whether it was by the department or the court or by myself, she did. It's true, of course, that there was a dependency case that began either late 2020 or early 2021. However, there has never been a finding by any court that my client used drugs in the presence of the child. The father keeps making that argument. Him making it over and over again still does not make it true. Yes, my client, the mother, entered a consent to the dependency case and went through a case plan and agreed that she had used drugs and tested positive for the child was born, but never that drugs were used in the proximity to the child. The father's argument seems to hugely disregard every witness that wasn't Dr. Wallace. Here, my client had Jennifer Kiss testify, as the court mentioned. She was the dependency caseworker who, of course, was assigned by the department to oversee the child and the case plan and help assure that my client got through the case plan. Certainly should be, 1, unbiased, and 2, very much looking to protect the interest of the child. Also had Susie Morris, who was the guardian ad litem, again, a person appointed by the court to supervise my client and ensure the safety and well-being of the child. Also, Dr. Natalie Pratt, one of the mother's counselors, another counselor, Maria Campanucci, Norelle Lacrosse, a longtime friend of the client, and Mr. Mantella, who's the boyfriend. All of those folks testify in support of my client. None of them testify that my client was a danger to the child. The father wants to seem to focus on everything that occurred prior to these cases. As has been mentioned, my client took over 50 drug tests and passed them all. And I say passed with the caveat that she did test positive once or twice, I don't recall exactly which. However, it was found by the dependency court that that was after she'd gone to the emergency room and was prescribed medications. She took those medications pursuant to the prescription for a matter of a few days, a week at the very most, and tested positive for that drug that she was lawfully prescribed. Other than that, she has never failed a drug test. Worth noting that as part of the final judgment, she's been doing hair follicle testing every 3 months. She still has never failed a drug test. Here we are, this is a 2021 case that was initiated early in 2021, meaning the case has been around for around 5 years. And my client has not once, but for the aforementioned test from the emergency room visit, tested positive for drugs, not via a urine sample and not via the hair follicle testing. She continues to this day to do everything that has ever been requested of her. The father relies heavily on Dr. Wallace, and I'm generally not a fan of hyperbole. Here, though, I would submit to the court that Dr. Wallace, her testimony was bought and paid for. She was paid $14,000, all of that from the father. She did not receive a penny from my client. She was only put into the case because Mr. Simpkins wanted her to be a part of the case. And as is borne out of the transcript, he ultimately gave my client one more day of time sharing every week to allow Dr. Wallace to be appointed. That was the only time that he ever agreed to allowing more time for the child. It's our perspective that this hugely falls within the discretion of the trial court. And as to Dr. Wallace specifically, the court, of course, has access not only to the transcript, but to her reports as well. In her report, she had a great deal of negative things to say about the father. The father was alleging that the mother was doctor shopping, this despite evidence to the contrary of the doctors being fully vetted. The father being so petty towards the mother that he wanted to schedule an appointment with Dr. Wallace to discuss what he thought were excessive mosquito bites on the child after being returned from the mother's time sharing. Another example Dr. Wallace gave of the father's pettiness was that the mother sent him a picture via text message with the mother stating the child had hit her cheek. There was a bruise due to falling into a piece of furniture. Mr. Simpkins brought the child to the office of Dr. Wallace to show the bruise, indicating he believed that the child was being hit by the mother or her boyfriend. Again, the father making false allegations towards my client or her boyfriend.
Counsel, let me ask.
Yes.
The hyperbole aside, I mean, experts are paid, and that's fine, and that's litigation. So that doesn't carry all that much weight with me. But in any event, getting back to the start of the trial under 61.13, I mean, your side was asking for equal time sharing, right?
Yes, sir.
All right, and there's, if I understand the statute and read the statute, there's a presumption of equal time sharing.
Absolutely. Yes,
when
sir.
you walk in. So before anybody opens their mouth, that's what the trial judge is looking at.
Yes, sir.
Apply the plain language of the statute. So if one of the parties, in this case, the father, wants something different, then he has the burden to overcome that presumption, right?
Yes, sir.
And if I'm listening to the argument, your opposing counsel makes strong arguments, and you're making them strong. It seems like you're saying that, look, the trial judge weighed the evidence, and you as the appellate court can't reweigh the evidence. The trial judge decided what the trial judge, in other words, if the trial judge would have made it less than 50-50, you would have to show us why that's been an abuse of discretion and why there was no competent substantial evidence. And so it seems like your position, and I'm not trying to put words in your mouth, is the trial judge heard what the trial judge heard. There was certainly issues about your client's history. Father makes good arguments about scenarios that was in your client's past regarding other children. But at the end of the day, the trial court listened to all the evidence. There was conflicting evidence. The fact that one was maybe more of a highly qualified or credentialed expert, trial judge has the ability to listen to conflicting evidence and make the call that the trial judge makes, as long as there is some evidence to support the judgment that was rendered. I mean, isn't that kind of where we are today?
Yes, sir, it absolutely is. And along with that, it sort of is confounding to me that the father wants to keep making the argument that the mother had this burden of proof. The mother did not. The father had the burden of proof of demonstrating, contrary to the statute, that the court should not award 50-50. As you indicated, Your Honor, when we walked into court that day, my client was presumptively entitled to equal time sharing. It was the father.
As was the father.
Yes, absolutely. And we never argued for anything other than that. We always argued for 50-50. It's our perspective that there is a great deal of substantial, competent evidence to demonstrate that my client was an appropriate parent. All of the aforementioned witnesses, the guardian ad litem, the DCF caseworker included, stated there was never any harm to the child in the care of my client. Commercially, they also all testified the father was extremely difficult to deal with. He didn't like DCF coming to the home. He didn't like DCF having contact with the child. He refused multiple requests of theirs, including one time simply to place the child down so the child would be free to move about. He refused all of those things. The father has been, opposing counsel earlier used the phrase disturbing case. I would agree, but for an entirely different perspective. This father was, and again, excuse the hyperbole, but one of the most difficult parents I've ever had to deal with. He objected to literally everything that we did. We had to file a motion in dependency court every time to request more time for my client. DCF would agree to it. The guardian would agree to it. Only Mr. Simpkins would object to it. It was always Mr. Simpkins making this case difficult. All my
Well,
clients.
he's concerned about the child. So I mean, that's, you say you don't want to use hyperbole, but don't use hyperbole. Then just let's continue on with non-hyperbole arguments here. How about that?
Understood.
I mean, at the end of it, there's competent, substantial. You don't even, if there's some competent, substantial evidence that favors the trial court's ruling, the fact that there's competent, substantial evidence that would have favored a ruling in favor of the father, that's really not our task to worry about, is it?
No, sir, not at all. If matter of fact, if that's what the court finds, I win. The trial court's order will stay in place because there's substantial competent evidence on either side, including importantly on my side of this argument. If the court finds that, then you have to leave the trial court's findings in place. It's our perspective.
What
Yes,
about the arguments about the delay in the entry of the final judgment and the alleged inconsistencies between oral pronouncement and the written judgment itself, the last two arguments collectively in the briefing raised by your opponent?
I think a fair portion of the delay is attributable to the clients. If I recall it correctly, post-trial and pre-final judgment, the father filed 6 motions: motion for contempt, motion for clarification, motion for child hearsay, and on. He filed 6. I believe we filed 3. So there were 9 motions filed post-trial and pre-final judgment. My point being, we were giving the trial court plenty of work other than actually coming up with a final judgment. I don't know how the father can file 6 motions and then argue that there's been delay between the end of the trial and the final judgment.
I mean, in all due respect, the judge could just say, okay, I see those motions. Here's my judgment. I will then address the motions post-judgment.
I suppose that the court could do that. However,
Sure, they could. Why not?
Yes, sir. I think, though, we're all very much aware that our trial courts are overworked. They're overburdened. There are too many cases. This particular judge, Judge Spiker, she was actually in the process of transitioning from family court, where she had this trial, to criminal court. When she finished this case up, she was actually already in the criminal court, but continued handling the case because, of course, she was the one that sat in capacity as the trial judge. So she kept it and maintained it. But my point is, not only was she very busy in transitioning to a new docket, but we kept her very busy with the filing all those motions. I don't believe there's anything in the record that would indicate that the delay here caused issues sufficient to the extent that her judgment should be overturned. I addressed all of the father's cases for that argument. I think they're all easily distinguishable from the case that we have here today, and I do not believe that warrants overturning her judgment. The last argument that the father made was that there were conflicts between the oral pronouncement and the written judgment. However, the father gave not a single example of that happening. In his brief, that argument starts on page 63. And then in my brief, I addressed that issue on page 43 of my brief, where I indicated that the father had given not a single example of that taking place. And then in response, in his final brief, the father then, on page 19 of that brief, he actually has verbatim the identical paragraph he had in his first brief. To be clear, the trial court's final judgment greatly conflicts with the trial court's oral pronouncements, its well-established principle, et cetera, et cetera. So after I pointed out there was not a single example, his response still contained not a single example and had the identical paragraph arguing in support of that the court should overturn the judgment based on there being conflicts. It's our position that the second and third arguments given by the father are essentially, I'll throw that out there and see if it sticks to the wall. Seems to be very little thought by the father in support of that argument. Again, even after I point out he gave no examples, he still gave no examples of that being the case. Here, the issue really comes down to, as the court has indicated, the substantial competent evidence to support the mother's position that she was entitled to and should maintain the 50-50 time sharing. The case law is clear that that's exactly the situation we have here today. If there is substantial and competent evidence to support Judge Spiker's ruling, then that ruling has to stay in place.
I mean, how much time sharing did the father agree to in the lead up to the final hearing, the temporary order or the agreed upon temporary order?
Well, all he ever agreed to was a single extra day every other week.
Which
and
would have
that-
made it how many days? In a 14-day period, how many days would have that been for the mother?
That gave her 6 days out of 14. She had 1 day less than 50-50. We went to trial over 1 day because
So what you're make sure I'm clear with what you're telling me. So leading up to the trial, the time sharing arrangement that the parties had using a 2-week time frame for my ease of math, father would have 8 days and mother would have 6.
yes, sir.
So the net result now after the final judgment using my time, I mean, I know there's a different blocks of time, but in essence, father has 7 and mother has 7.
That's exactly right, Your Honor. It changed the time sharing schedule, changed by a single day over a 2-week period from an 8-6 split to a 7-7 split. And again, that's an example of the father being difficult. He lost a single day every other week. And here we are 2 years later, appealing the case and trying to close out the appeal over 1 day out of every 14. But for Dr. Wallace's entry, he has never agreed to any additional time for the mother. And even in Dr. Wallace's report, she indicates that the father may never believe that my client can be a good mother. And that seems to be the case with Mr. Simpkins. He has always fought against everything she has ever filed in court.
He has the right to believe that she may not be a good mother, and that obviously is evidence that the trial judge would consider, I guess, in the analysis of what to do.
I suppose so. There was, for the court's edification, a day in dependency court where Mr. Simpkins actually stood up and said, I will fight this to the very end. I will take this to the Supreme Court if I have to. I will keep fighting until somebody listens to me. And I agree, Your Honor, he's certainly entitled to protect his child, but he's gone way beyond that. The guardian ad litem testified he went way beyond that. The DCF caseworker testified he went way beyond that. He continues to go beyond that. Here we are now 5 years into this case. 5 years. My client has not once tested positive for drugs. She has not once caused harm to that child. Law enforcement's been sent by the father and his adoptive mother on at least 3, if not 4 occasions to investigate mother or her boyfriend. And not once has any arrest been made. Not once was anything filed with the court indicating harm to the child at the hands of the mother. Not one time in 5 years. Even Dr. Wallace was saying that my clients had done extremely well, and the father refuses to recognize that. And that's why this case continues on, because the father refuses to recognize that. Judge Spiker did recognize that. Judge Spiker
Well,
was,
I mean, just so we're clear, we don't know what's happened over the 5 years. We know from an appellate court standpoint, we know what's happened according to the record we have.
that
That's
record,
that's what we limit ourselves to.
absolutely,
Whether
Your Honor.
anything's happened in 2025 after the briefing's been done, that's
There will-
neither here nor there for our position. That might be a trial court matter, but
Yes,
until
sir.
that's brought into our record, that's a non-event to us. So
The record that the appellate court has will not show one single harm coming to this child at the hands of the mother since these cases began. Everything argued by counsel was prior to these cases beginning. The DUI arrests were years ago, and if I recall correctly, at least one of them was reduced to reckless driving, and they were both before the child was ever even born. Everything the father brings up was prior to either of these cases beginning in late 2020 and early 21. There's not been any harm to the child since, and the court's record will reflect that.
Well, but I mean, the point, it's fair for the father to bring up however your client was leading up, before birth, after, you know, what have you. That's a fair topic for him to present to the trial judge. What weight is to be given to it by the trial judge is obviously what the trial judge is tasked to do, and then apply the law to that evidence. So, I mean, there seems to be, if hyperbole is the word of the day here, there seems to be hyperbole on both sides here. I mean, the judge heard how your client was, the judge heard how the father was, the judge had the statute, the judge listened to testimony and rendered a ruling. I mean, that seems to be where we are, finger pointing aside.
I think that the Mother's Day is a classic example of the father. I'm sure the court has read through the transcript and the brief. There were 3 Mother's Days during the pendency of these cases. And every single time we had involved Dr. Wallace, if she was involved in the case, and both the attorneys, just to get the father to allow time sharing on Mother's Day. And I think it's ludicrous that I have to say that, but that's precisely accurate. We had to get him to allow time sharing on Mother's Day. He would make plans months in advance and tell the mother, oh, I'm sorry, I made plans. You can't have Mother's Day. It's abundantly clear from the transcript that he refused to give her even Mother's Day. And you would have thought that after we had to fight for the first Mother's Day, he would have given her the second. No, sir, he did not. You would think after the second one, and we had to fight to get that, he would have given her the third. Again, no, sir, he did not. All 3 times we had to beg, grovel, and plead just to get my client, the mother, time sharing on Mother's Day. And that, in a nutshell, is what you have with Mr. Simpkins. He cannot, he will not be reasonable with this mother in this case, and that continues to this day with him fighting against everything that she's requested. Any other questions from the court? And I see my time has come to a close.
Thank you, Mr. Albert. Ms. Haas, you may continue. You got about a little over 3.5 minutes.
I'll try to talk fast. I'm going to respond. First of all, with regard to Mother's Day, respectfully, opposing counsel statement is incorrect. Mr. Simpkins had offered Ms. Nuss Mother's Day in the year preceding the trial in this case, and she was granted Mother's Day and failed to appear. So a lot of these statements are actually inaccurate. There was never testimony by the guardian ad litem or by the dependency caseworker that Mr. Simpkins was doing anything inappropriate to protect his child. In addition, I will tell you quite frankly, the order, the disposition order in the dependency case, and I don't know why this is still an issue, and this is found on the record at page 808, it says the mother has harmed the child in that she has exposed her to a controlled substance. The mother did drugs in the presence of the child. That's what the order of dependency said. So I don't know why there's still a dispute with regard to that. With regard to the issue of the shifting of the burden. So that's very interesting because yes, while there's a presumption of equal time sharing, the final judgment in this case, and you can find this at page 1939 of the record, it says the court finds that any potential rebuttable presumption was overcome by the mother to a preponderance of the evidence and that a 50-50 time sharing plan is currently in the best interest of the minor child. So at no time during the trial court's oral ruling did the trial court make any findings that any potential rebuttable presumption was overcome by the mother by a preponderance of the evidence. In fact, the only reference the trial court made to burden shifting in this case was when it enunciated its oral ruling, and it said the statute does have a presumption of 50-50, and I think regardless of how that burden shifts, ultimately at the end of the day, the court can only award time sharing that's in the best interest of the child. And we would submit to you again that the substantial competent evidence does not suggest in this case that equal time sharing is in the best interest of the child. And in fact, with regard to the question as to the time sharing schedule, yes, there was a temporary agreement for mom to exercise 3 overnights of time sharing, but the only reason that Mr. Simpkins entered into that agreement was because he wanted a social investigation in this case, and the mother adamantly refused. And in fact, Mr. Simpkins' request at the trial was for less time sharing. It was for the court to adopt Dr. Wallace's findings, wherein she recommended no more than 2 overnights. So it's not that he was fighting about 1 overnight, as my esteemed opposing counsel suggests. He felt that limiting the mother's time sharing, given her history and given what was going on in the case, was imperative because, again, she was still drinking during the course of the proceeding. She was still drinking right before the trial when Dr. Wallace testified. And in fact, Dr. Wallace filed an updated report just prior to the trial. So again, we would submit to you that the competent substantial evidence in this case did not support shared parental responsibility, that it was the mother who was unable to meet her burden of showing that shared parental responsibility was in the best interest of the child. And all of the testimony before the court to that date indicated that the mother could not share parental responsibility. And that same was in fact detrimental given her conduct, not years ago, given her conduct.
Ms. Haas, your time has expired.
I apologize, Your Honor. Thank you,
Okay.
Thank you for the court's time today.
Thank you. And the case was very well argued. Thank you, counsel, and we are adjourned.
Thank you. Have a good day, everyone.
Thank you.